What is the job of the judges? It's to adjudicate the law as passed. And in the case of a Supreme Court justice, it is principally their job to adjudicate the Constitution. So, when there is an interest of having a conservative approved for the highest bench in the country, one needs to make a clarification here. And this is a clarification that is not being made often enough by people who ought to know better. And if you don't know better, I'm here to tell you better. Just saying. The role of a judge is not to adjudicate their personal values, their personal theology, or their personal point of view when it comes to these individual issues. It is not the role of a Supreme Court justice to be for the little guy, to be for the outcast, to be for the downtrodden, the people who don't have a voice. No, that is the job of the Congress to pass laws that do that kind of thing. The job of the jurist is to adjudicate the law as written and approved by other branches of the government. Now, when I say that, what I've just said, I have distinguished between two different types of conservatives, or two different ways of understanding the concept of conservative. When I say I want a conservative justice, I don't mean I want a conservative justice, or rather a justice with conservative political views who is an activist judge to enforce their views from the bench. What I want is someone who has a conservative understanding of the role of a justice to stick with the wording of the Constitution and the original intent of the Constitution. And the reason it's because the law of the land is the Constitution, and it is the law of the land that protects us. So let me just read something that I read in a news article that includes a citation from the Justice Amy Coney Barrett under consideration for the court, a high court. And this piece says that Barrett, in her opening comments, has cast herself as a judge who puts her personal preferences aside. And then she lays out what she said was a vital but limited role for federal judges. She said that the public shouldn't expect courts to resolve policy disputes or make value judgments, and that judges should not try to do so. This is exactly what I've just been expressing. That is a conservative understanding of the role of a justice. Now, you could be liberal, you could be leftist, you could be mainstream or middle of the road, you could be extreme right in all of your policy considerations and still have this view. That is, that you're not appointed to pass laws from the bench. Regardless of your own views, your job is to adjudicate the laws duly and properly passed by the appropriate branches of government, the legislative and the executive. And then she says, I believe all Americans of all backgrounds deserve an independent Supreme Court that interprets our Constitution and laws as they are written. And I believe I can serve my country by playing that role. That's what I like to hear. It does not matter to me what her personal values happen to be. It doesn't matter what her personal theology happens to be. She could be an atheist for all I care, because those are not matters that are under consideration by the court, by an appropriate use of the court. She is not adjudicating theology. She is adjudicating the Constitution of the United States, All right. So with that in mind, then, what's all the hubbub? Well, the hubbub is for the last 20 or 30 years. Well, way more than that. At least since 1973 in Roe versus Wade, but even before that, it was starting. There was a new principle or a new way of understanding the Constitution. And that way of understanding the Constitution was that it was alive. It's a living Constitution. Now, this is a nice way of referring to it because it sounds good. It sounds noble. It sounds respectful. It sounds like we have a high view of the Constitution when we say it's alive. But that is not what it means. This is not a high view of the Constitution. It is a low view of the Constitution. In fact, it is a view that, for all intents and purposes, really functionally eliminates the Constitution entirely. Because the Constitution is a law established by founders for a specific purpose. But according to the living Constitution mentality, the purpose of that law is not determined by the founders who wrote it, but it's determined by the judges who interpret it. And that's why they can find whatever they want to find in the quote-unquote Constitution, because the source of the law is not objectively in a proper understanding of the meaning of the document itself. That's Comey's view, Coney Barrett's rather, but rather in the minds or hearts or judgment or value system of the judges themselves. And so characteristically, those who have been conservative justices are tend to be rather conservative politically in the ways that they, in the consequences of their views, because the country is rather conservative. And when the country, being conservative through their elective process of their representatives, do not accomplish what a smaller group of people want to have accomplished, then they go to the courts to get them to do it. To find activist judges, to find things and interpretations and angles between the lines of the Constitution, like a right to get an abortion, and then adjudicate from the bench. Rather, I should say legislate from the bench. Now, let me tell you why this is dangerous. It's dangerous because on that view, there is no protection from the law. With protection from the law, that is, in the law is what I mean. The law no longer protects you because the law doesn't mean anything in particular. It only means what a justice says it means. Now, if somebody doesn't like what the Constitution says, and by the way, the Constitution itself is really a structure of how the government operates, and so whether it was a bunch of racists or white men or bigots that formed the Constitution is completely irrelevant to the structure of the Constitution, which does not bear those marks. But then you have the Bill of Rights that has a lot more content about particular things, and what the Bill of Rights turns out to be, and the subsequent amendments, are changes that the people think are good to make in the Constitution to make the Constitution a better Constitution. The first amendments were the Bill of Rights, and then we've moved beyond that to bring equality. And so, therefore, there is a way, if you don't like what the Constitution is capable of doing in the present circumstances, and the laws that you pass are not adequate to accomplish the equity and justice that you desire, it's possible to modify the Constitution. It can be amended. It's not easy. You need 2/3 a majority of the states approving it. You need a supermajority in the Senate to even get it going. I mean, this is not easy to do. And the founders intended that way so that the protection provided by the Constitution is not here today and gone tomorrow based on the whim of some politician or on the whim of the voters. It's hard to change the Constitution, at least as written. But there's an easy way to get a de facto amendment. And all you need is 5 people in black robes with the idea that the Constitution is alive, and they are the ones who are determining what that living meaning is. And they rule based on their intention in a way that the Constitution itself does not imply, and they effectively change the Constitution without the projected without the required majorities that the founders had in mind. 5 people can amend, for all intents and purposes, the Constitution when you have a living Constitution idea about how this works. And it turns out that the notion of living Constitution simply means that the Constitution is alive in the minds of the jurists. That's what's alive and active. I think the Constitution is alive. It's not dead, although that's the way people would like to characterize me who disagree with my view on this. It's alive with its original intent, and that's what protects us. That's what it means for a country to be a country under laws. We have the rule of law, and the law means a particular thing. Whatever law it is, it means something. It was passed for a reason, with particular intentions. And it has force based on the intentions that were expressed when it was passed and duly passed by a proper majority and a signature by a president. Okay? That's what protects us. And when those laws become alive, then they cease to be anything in particular, and the only thing that is alive is the imagination of the jurists.